Hello, everyone. Welcome to the International Commercial Arbitration class. For the chapter 2, we are going to talk about the different applicable laws and regulations intended for international commercial arbitration. One advantage of international arbitration is the likelihood to avoid choice of law difficulties that unavoidably arise in international disputes. It doesn't mean you should not choose a particular law, but for safeguards, it is written in the contract. Today, we will identify the applicable international rulings, okay, for commercial arbitration. Let us determine how laws and regulations are being applied, okay, if there's any dispute arises between two foreign firms. And also let us familiarize with the important rules and regulations in international trading. Let us begin with defining of different terms so that as we go along with our discussion, you will identify the different terms being used throughout the courses. Number one, tribunal court. So when we say tribunal court, is it either a person or institution that has the capacity, okay, to mediate, okay, or they are authorized to judge, okay, and evaluate a particular dispute. Substantive law, these are the set of laws that governs how members of society are to behave. Example, the law of contracts, wrongdoings, wills, and real property. Okay? And for the procedural law, this comprises the court ruling, how the procedures of resolving a particular dispute should be handled or should be undertaken, or we simply call it like hearing. Okay, hearing. Next is the National Commercial Arbitration Law. These rules and regulation cover the domestic commercial dispute if there will be some a dispute within the local commercial companies. The National Commercial Arbitration Law will facilitate that. So you could expect the participants of this dispute are local commercial entities. Then the opposite of national commercial arbitration law is the international law. So rulings, okay, if the participants are uh, from different country or this when the dispute arises from international traders. Governing law, this is a clause used in legal agreements wherein you can declare which rules and laws will govern the agreement if legal issues. So it will be decided by both party of what kind of ruling they are going to use. Either they're going to follow a particular institution like International Chamber of Commerce or a private institutions like Silicon Valley International Commercial Arbitration Center, or they're going to follow United Nations International Commercial Arbitration. Okay, so those are the some of the choices. Okay, so when both party agreed, okay, which kind of legal agreements they are going to use, definitely they're going to follow the ruling of that particular institutional arbitration. Applicable law means all applicable provisions of constitutions, laws, statutes, ordinances, rules, treaties, regulations, permits, licenses, so all of the applicable rules and regulations. So if one party violated the patent regulation like copying, the model of the cell phone, or copying the name of a particular product or institution, okay, they are subject to face a particular law, okay, applicable law, and that is intellectual property infringement. And if it is related to criminal law, okay, or civil law, okay, the applicable law, of course, is the national law. And the last one is the proper law. It is applied in the choice of law stage of a lawsuit involving the conflict of laws. Okay, so meaning it is also similar with the substantive law, okay, applicable where conflict of laws occur, or which determines under which jurisdiction or system of law. Okay, so which law, okay, should be used. For example, in international sales of goods agreements, the law of the seller's country is normally the proper law, okay, in case of dispute with a foreign buyer. Choosing of applicable law is upon the agreements of both parties. If parties have failed to agree, the arbitral tribunal will choose the law applicable depending on the facts of the case at hand, using criteria such as selecting the law with the closest connection to the dispute. Remember, the goal of any arbitral tribunal is to establish the material facts of the dispute. Tribunal is going to evaluate the contract if it is valid. Then, tribunal will check other relevant documents and identify which rules and regulations applicable to the dispute. The rules to be used is upon the agreement again of both parties, either use of institutional arbitration or ad hoc. When we say institutional arbitration, you are going to follow a particular rules and regulation of existing institution. Like what I had mentioned, the ICC, International Chambers of Commerce, uh, the United Nations International Commercial Arbitration Committee, and then you can use also the World Trade Organization policy if it's bigger scope of one country to another country, and also you can use the different treaties, okay, the New York Convention, the model law, okay, those are the institutional, meaning they already have created a particular rules and regulation. You are just going to adopt it. And when you adopt it, you're going to inform them if they're going to submit an application and they're going to conduct the proceedings. Or number two, both party can agree if they want to use ad hoc, meaning they're going to set up their own rules and regulations. Okay, so a specific example, okay, of this kind of dispute. Okay, these are just only one of the million cases in international trading related to patency or intellectual property right. Okay, so this is the issue of who is the original owner of device or software features. Okay, so let's take a look on the case of Samsung and Apple. The case is all about Apple as a claimant, okay, claiming that Samsung had copied a feature of their mobile phone. It took them 7 years to resolve the disputes, and eventually they decided to settle the case via arbitration. Okay, patent disputes such as Apple-Samsung litigation would be resolved effectively and more effectively. Another case is the Colombia versus Panama. Okay, this case was being filed in World Trade Organization. Okay, the case all about Colombia had imposed tariff, okay, and unnecessary tariff for Panama, and then World Trade Organization favored Panama against Colombia because they say that the tariff imposed to Panama is unnecessary. Okay? And the last one is the case of Japan and South Korea. That it is also recorded in World Trade Organization, which favored Japan to impose countervailing actions to offset the impact of South Korea action to exportation of dynamic random access memories from Korea. This is just only one of the common dispute. Okay? Remember, international arbitration is a smarter strategy which provides a reasoned, globally comprehensive decision with time and cost savings, according to Glenn Benton of Silicon Valley Arbitration and Mediation Center. That's why, if it is international dispute, they really advise to resolve the dispute out of the court. Because arbitration has a characteristic that when you use this kind of mechanism to settle the dispute, it would really give you less like hard time. Okay, it would give you some sort of convenience. Okay, and the arbitration is consensual, meaning it is being agreed by both parties. Unlike in the court or litigation, you have to follow whatever the rules and regulation of the court or the Supreme Court. Okay, arbitration is being done in a private session. Okay, and it leads to a final and binding determination of the rights and obligation of the party. It provides win-win position and solution for both parties. Therefore, they choose international commercial arbitration to separate them from national law and set their own rules by looking into international arbitration guidelines. They can choose persons with specialized knowledge to judge their dispute. For example, lawyer, engineer, industry practitioners that is highly knowledgeable with a dispute object. So this entity is chosen for a specific dispute. In international commercial arbitration, arbitration is not subject to appeal on the merits. Once the decision is final, okay, it should be enforced or it should be rewarded. Okay, it should be applied. Okay, unless the reward or the final decision is unacceptable and has a legal violation. And more so, arbitration has a faster decision and lower cost compared to litigation. The international commercial arbitration is a work in progress with the objectives of member to promote fair trading. There are a lot of initiatives to improve the system of arbitration and procedures. Since 1920, member countries begun in Europe had come up with several rulings of resolving disputes. Despite of some difficulty, like one country will agree with the rulings or compromise or not compromise with the agreement, still they were able to establish a guidelines and rulings for international commercial arbitration. That's why in the 1923 protocol, they eliminate some of the non-domestic arbitration agreements. Okay, so those are the actions that really not appropriate for the court action. Okay, like what Ed said, they limit the involvement of national law, okay, in regards with international commercial arbitration. So they want to have the separate rules and regulation. Okay? And even after this time, International Chamber of Commerce and different institutions worldwide is in progress of developing dispute settlement regulations. There are a lot of agencies that provide services on how they're going to give assistance to those firm who experience this kind of dispute with other country. Due to discoveries in ruling loopholes or different difficulties in implementing the arbitration agreements, ICC took an initiative to develop more practical and relevant guidelines. For example, the decisions of arbitration award shall enforce where the proceedings had been undertaken. Okay, so this is one of the results in Convention on the Recognition and Requirements of Foreign Arbitral Awards in New York. That is why it was called New York Convention. And then followed by other rules modification, new creation of organization and conventions or a series of meetings held in different countries. That's why in 1961 they have the European Convention, then in central arbitration rules had been set, and then model law in 1985 had been also being created. What are the applicable laws for international commercial arbitration? Okay, you could see there the three applicable laws. Okay, number one, international treaties. Number two, national laws. Take note of the national laws. If the dispute is related to civil cases or criminal cases, that is the only time that national law could intervene. Okay? And in terms of like another one is the arbitration rules. Okay, so but these kind of law must be written in the contract of commercial transaction. Okay? It must be stated in um, commercial contract. Okay? For international conventions or treaties or agreement, okay, this is being created by different representative of nation or countries. Okay, we have New York Convention as the founding stone of the entire commercial arbitration. There are 135 states ratify or approve the convention committed to recognize arbitral agreements. They also have the Geneva Protocol of 1923, enforcement again also of arbitration agreements, and the Washington Convention and the Moscow Convention of 1972. Okay, so they want to promote the socialist economic integration. Every region, every continent, okay, they have a particular agreements or treaties that been created. You have there, you could see in the screen, the European Convention of 1961, the Washington Convention, the Ancestral, and the other ICC rules. The common and the famous and the leading arbitral institution, we have the International Chamber of Commerce. Okay, so the ICC solved the most difficult dispute in international trading and investment since 1923. They act as sort of government and international business and provide services designed for a particular dispute. In international arbitration, they have an independent ruling in resolving dispute. However, national law is applicable if both parties agreed to use national law, okay, of the seller, or if the law, okay, is governing like or related with the civil cases, okay, violate human rights, okay, the national law is applicable. But particularly in 1985, under the United Nations, they had come up with rulings like the model law. Okay, no court shall intervene except by the provisions provided in the law, as I had mentioned, if it is related to like even criminal cases. Okay, even criminal cases. Okay, so they have a protocol. If it is like the if the criminal case is being done by a foreigner, okay, the embassy, okay, or the consulate of that country is going to take the proceedings and file if they have an agreement with the local government, okay, it will take effect. But if they don't have an agreement with the local government, okay, the national the national ruling will take effect. Like for example, if an American in our country, in the Philippines, if American soldier had violated our rules, since we have treaty with United States of America, um, the proceedings of the process of hearing or evaluating the case will be done and handled by United States, okay, not in our country. Okay, if the victim is a Filipino, still the proceeding will be done in the country in our country, but the enforcement of the violation, okay, it will be implemented by American soldier by the American government. With the privilege of both party to select the kind of ruling they want to follow, okay, we can call it like a governing law. Both party can agree which law they will use to implement in times of dispute to court, and we call it governing law or choice of law. The third applicable law is, of course, the arbitration law. Any arbitration that takes place in the context of an institution or ad hoc will be conducted in accordance with the rules of the organization. The rules set forth the procedures for the application of the arbitration, the appointment of the arbitrators, the conduct of the proceedings, and the issuance of the award. The convention requires courts of contracting states to give effect and enforce arbitration awards made in contracting states. Whatever the decision given by the arbitration tribunal court on the basis of merits evaluated by governing law, remember we're always on the basis of the chosen law, okay, the solution to dispute must be enforced or awarded. Law is applicable to the recognition of enforcement of an award that is being sought, okay, where debtors' assets are located. Okay. So what is in the contract may be followed by both parties or arbitration or settlement of dispute. Okay. At the end of the arbitration, still both parties will be given an opportunity to present their solution. Okay, and then the arbitrator is going to evaluate and they're going to talk about and make some negotiations or bargaining about the solution. Okay, if I am a claimant and my accusations are valid, okay, and then the respondents most probably they're going to agree, and what they can do is to appeal, okay, to lessen uh the effect of this kind of ruling or the award. Okay, the respondent, okay, may appeal, okay, to lessen, like for example, to minimize the payment if it is involved if it involves monetary or a penalty, okay, claimed by the claimant. So that could be settled, in arbitration. Okay. Many countries have incorporated into their laws to the New York Conventions of 1958 if they are going to use institutional arbitration. Again, if the dispute is related with civil laws, national law is applicable. Okay? If the dispute arises related to intellectual property between different country, intellectual property rights, okay, of World Trade Organization must be followed unless it is not written in the contract. Okay? Award will be based on the chosen law governing in the contract. The good thing with arbitration is that the party has a freedom to select applicable law for themselves. UNCITRAL, or the United Nations Commission on International Trade, law arbitration rules provide a comprehensive set of procedural rules upon which party may agree for the conduct of arbitral proceedings arising out of their commercial relationship and are widely used in ad hoc arbitration as well as administered admins arbitrations. In general, UNCITRAL aims to promote assistance in modernizing laws or arbitral procedures that will help practitioners understand and benefits on this regulation. They had developed a clear arbitral proceedings on how to enforce the award. Okay, so you may check the ancestral arbitration rules on Ryan for you to specifically know how they're going to do that. But as we go along with our discussion, we will discuss them one by one, especially when we are in the arbitration procedures. We're going to check the different standard procedures of ICC, um, UNCITRAL, then the other institutional center for conducting this kind of arbitration proceedings. Here are also some of the specific lists of other institutional international commercial arbitration. Here in Korea, we have the Korea Commercial Arbitration Board. Then we have Hong Kong International Arbitration Center. That's recently Korea Commercial Arbitration Board had joined and or partnered with Hong Kong International Arbitration Center. Okay, and I given and mentioned a while ago also the Silicon Valley Commercial Arbitration Center, Shanghai International Arbitration Center, China International Economic Trade Arbitration Center, and Trade Arbitration Commission. Okay, in conclusion, there are different types of law that are applicable in international commercial arbitration. Okay, you can use international treaties or convention. You can use the national law related to civil law, okay, or criminal law. But if you want to follow the model of 1985 law, okay, you are not going to allow the national law to interfere with your dispute resolution. Okay, and another thing, in there are two types of arbitration. If you want to the third one, arbitration. If you want to use arbitration, either it is institutional or ad hoc. Again, for institutional, you use the existing established different international commercial arbitration centers in different countries, okay, that you may think convenient and applicable for your dispute. And lastly, it is upon the decision of end user what is the applicable law they want to use as long as it is written in their contract. Okay. If you want to read and understand more about the applicable laws in international commercial arbitration, I had posted here some of the additional reading resources that you may use, okay, in times that you want to have some additional information and to validate some of the information given in the chapter 2. Okay? I hope that you could be able to understand because this chapter is kind of short because I want you uh to know and fully understand what are the applicable rulings, okay, or applicable rules and regulations, okay, that you may use, okay, in international commercial arbitration. Okay, there are a lot of available rules and regulations. Okay, so it just check if it is written in the contract. Okay, so in the future that you will be working in international logistic companies, okay, and you have the capacity, okay, to depend, okay, the dispute, okay, you may use this kind of guideline. Okay, if you have any further questions or follow-up questions or clarifications in regards with chapter 2 or for the applicable law, please let me know and send me a message. That's for today. Thank you, everyone.